One of the ways that we try to avoid trial in a circumstance where we can't seem to reach a settlement on our own is to use a form of alternative dispute resolution. Most people have heard of arbitration. That's simply a matter of hiring an experienced attorney or a retired judge to come in and listen to both sides and put a number on the case, and in advance both parties have agreed to live with that number. And that's the end of the case. There's no appeal, there's no going to court, and whatever that number is, it is. Sometimes there'll be a high-low arrangement where, regardless of what the award is on the part of the arbitrator, the award can't be any lower than a certain number, or it can't be any higher than a certain number to avoid wild card type results. That form of resolution, while good, still removes the ultimate decision making from the client's grasp. And what has become extremely popular and effective over the last 10 years in Virginia and elsewhere is mediation. And mediation is fundamentally a different process than going to trial. Mediation is a process that involves both sides coming together, typically in a room like this with a retired judge, and the plaintiff, my client, gets a chance to tell the other side, usually an insurance company, its adjuster, its attorney, sometimes the defendant comes, just exactly what they've been through, what their injuries are, what those injuries mean to them, how those injuries have affected their work life, their family life, their parenting, any of their hobbies, any number of things. And the other side hears that. The other side often will take that opportunity to explain what their role is and how they view it and how they have to look at the case from the perspective that I've just described of how a jury is going to react to this particular set of facts. At the table is a retired judge who is trained in mediation, and after that initial session of going back and forth with both sides in terms of what their feelings are about the case and what their roles are, the judge will usually separate the parties and will spend literally hours going back and forth between each of the parties. They're called caucuses, and will elicit offers, counteroffers, offers, counteroffers, back and forth in hopes that the parties will together achieve a settlement. And about 90% of the time that occurs. And what is different about that than going to court, and at court an end is achieved, no question about it, but the client owns the result in mediation. The client has participated in it from beginning to end. The client at any time can say, no, this is not what I want to do, I'm going to go to court. That option remains throughout the mediation process, and it's to a certain extent empowering. It keeps everybody honest. Both sides know that if they don't put their very best effort and offers forward, that there's a good chance that the whole effort will be wasted and they'll end up in court. So we have found that mediation is an extremely effective tool, and that it is very satisfying to clients, and will often carve as much as a year out of the process, such that clients get resolution and get the opportunity to have closure and move on with their lives. As you might expect, there can be some creative and imaginative combinations of these mediation and arbitration. They have sometimes what's called med-arb, where when the mediation breaks down, the parties have already agreed that if it does break down at some certain point, then the mediator that everybody's selected and who has now been extremely educated about the case is authorized and directed to put a number on it, and it becomes an arbitration. We tend to avoid that type of approach because it fundamentally alters the mediator's approach. Everybody's second guessing what they're saying because they're afraid that the mediation might fail. It ends up in arbitration, and they're afraid that some sign of weakness or some chink in their armor might be exposed, and the mediator will feel compelled, when he's an arbitrator or she's an arbitrator, to take that into consideration, and the award will therefore be reduced. So we tend to be fans of pure mediation because we think it gets the best result.